is Richard Land, and I focus on trust and estates work, as I said before. Tonight's program is on trust and estates, and it's really going to be broken down into 3 parts. Liz Hartery is going to be talking about kind of the basics of estate planning. She's going to lay the foundation for some of the things I'm going to say when I talk about the things you need to look out for when you review your estate plan and why a review is necessary. And then Alyson Marcucio is going to talk about some of the important issues related to elder law that we think everybody needs to know about. So let me introduce Liz. Liz has been with us for a little bit more than a year now. She comes to the East Coast from the state of Washington. She was lured to the East Coast by Yale, where she went to school as an undergrad. And then she went on to law school at the University of Virginia. She works with me and Alyson. She'll be working with Jim too in the trust and estates area. We pretty much work on everything together. I'm trying to take everything I have up here and transfer it over to her brain, which absorbs everything. So there's no reason to delay this anymore, so I'll turn it over to you.
All right, so I have a lot to get through. It's kind of hard to distill estate planning for beginners into one presentation. Although if this is your 23rd Trust and Estates presentation, this is probably a review for you. So some of the things that I plan to go over is really just a lot of the basic terminology that you run into when you're starting to talk about estate planning. I'm going to spend some time on the differences between wills and revocable trusts and some of the advantages and disadvantages of both of those. A little bit about dealing with incapacity and the different tools that you can use for that, including powers of attorney, living wills, and designation of healthcare representatives, and conservatorships. And then I'll talk a little bit on estate and gift taxes, although you'll see it's not nearly as big of an issue this year as it maybe was 5 or 10 years ago. So, what is estate planning in general? A lot of people just think estate planning is writing a will. I just need to go write a will. And it can and usually does involve that, but it has to do with both how you're going to plan to dispose of your property at death, but also managing your property during life. So one of the big things that you need to know when we're talking about the first piece of that, which is planning on where your property is going to go at death, is the difference between probate and non-probate property. So probate property is basically just property that's in your name that does not have some kind of contractual disposition, some way of telling someone via contract where your property is going to go. So an example of that kind of contractual definition would be beneficiary designations, say for your retirement accounts or your life insurance. Yep. Could you just slow down? Sure, I apologize. A little bit? All right. Okay, is that better? A little bit better? Okay, we'll see. Okay, so non-probate property includes things like property like life insurance and retirement accounts that have beneficiary designations. Most of those kind of accounts have beneficiary designations. So that would pass outside of probate. It's non-probate property. Also, joint ownership with rights of survivorship, which is very common, say, when you own your home with your spouse. Most of the time, that's owned jointly with rights of survivorship, which means when one spouse passes away, by operation of law, that property immediately passes to the surviving spouse. So you don't need to go through probate for that. And there are also trust accounts you might be familiar with in trust for accounts, maybe for a minor that has a bank account in trust for them, or revocable living trusts, which I will talk more about later. There's a difference between joint ownership with rights of survivorship and something called tenants in common. Tenants in common doesn't have that survivorship piece, so property that's owned tenants in common, your piece of that property still has to go through probate to get transferred. So after all of this, the only thing that a will actually disposes of is the probate property. Everything else passes outside of your will and outside of probate. So what is a will? A will is basically, you can just think of it as a sort of letter of instruction that a court is going to enforce for where you want your property to go when you die. The requirements to make a will in Connecticut: you need to have capacity, which means you need to be at least 18 years of age. You need to be of sound mind. You need to know what you own and who your natural beneficiaries are. And you need to know what the will itself says when you're signing it. You also need to be doing it voluntarily, so you can't be doing it under duress or having some kind of outside influence that's making you sign this will. It must be in writing, and it has to be witnessed by 2 people in your presence. One of the big questions that we get asked is, why do I even need a will, or do I need a will at all? So maybe you think that your property is pretty much all owned jointly with your spouse. It's all non-probate property. Your will wouldn't do anything. Why would you have a will? Or a lot of people think they just don't have a big estate. They don't have enough for it to be worth it to create a will for that property. But the thing is, and we see it a lot, is that it's really hard to predict what your estate is actually going to look like when you die. Sometimes, maybe say you die in an accident and there's some kind of wrongful death suit and proceedings from that, you could end up with a much bigger estate than you thought you would have had. Or you can also plan for other kind of contingencies, like sometimes we have after discovered. Have you ever gone on CT big lists, like unclaimed property? A lot of times we find that, and that has to go through probate. So it can make things more certain when you pass away. You can also select a fiduciary. So for a will, that would be an executor. So you can select who's going to take care of your property when you die, and who's going to direct where everything goes and take care of that. You can also usually, in a will, waive a probate bond, which is often required if the probate court has to appoint an executor for your estate. So if you have a will, you can waive that probate bond in most situations. And you can also plan for a lot of other special situations in a will. Like, say if you want to give some of your property to charity or a friend or a family member that wouldn't normally take under the intestacy laws, which are the default statutes that describe where your property would go if you don't have a will. You can also create trusts for minor children or spouses, and you can plan for maybe your child has some creditor issues, or you don't really think they have enough wherewithal to take care of their funds right now. You can name guardians for your minor children in a will. So it gives you a lot more control over what happens when you die and what's going to happen with your property. What is a trust? A trust is basically just a contract between you as the grantor and the trustee for what you want to happen with the trust property. Some basic definitions. The person who's creating the trust is called sometimes the grantor or the donor or the settlor. The fiduciary is the trustee. That's basically the person that's taking care of the property and is in charge of managing it. And then the beneficiaries are obviously the people who benefit somehow from that trust property, whether they get income that's thrown off of that property or if they get all of the property once the trust ends. So there are different types of beneficiaries too. There are multiple types of trusts, although I'm going to focus mostly on revocable living trusts. But testamentary trusts are those that you create under your will. Inter vivos trusts are those that you create while you're still alive, and those can be revocable or they can be irrevocable. So once you create that trust, you can't change it or take it back. You can also fund the trust during life, or you can leave it unfunded until you die. So there's a lot of flexibility with those kinds of trusts. A revocable living trust is usually one that you set up. You're usually the trustee of it, at least at first, sometimes with a co-trustee like your spouse or one of your trusted children. And it's usually funded during life for reasons I will explain shortly. So some other common uses for trusts that I've already kind of alluded to. Trusts for children, like if you have minor children, or not minor children who are at least 18, but you don't think they're really old enough to take care of your property yet. So maybe you want trusts for your children until they're 30 or 35 or 40, and then you think they'll be responsible enough to take care of it. A lot of times when we have people who have already created trusts for children, they up the age the next time that they revise their trusts because they've decided, never mind, that's not the right age. But you can change that in a revocable trust. Another reason might be trusts for if you have parents or other elderly relatives that you want to take care of while they're still alive, but you want to make sure that that property goes to maybe your children or somebody or a charity when they die. So you can put it in trust for them so that they're taken care of while they're alive, but when the trust ends, you still control where that property goes. Another thing that I think Alyson will cover in more detail, she deals with this more than I do, is special needs trusts. So if you have a child maybe with a disability and you want them to qualify for government benefits, but you still want to make sure they're taken care of in case those benefits don't cover everything that you'd like them to. So you can set up a special needs trust for them and try and help manage their property for them, especially if you think that they can't take care of it themselves. Trusts for spouses, this can come into play in a couple different situations. A lot of times it comes into play when it's a second marriage and sort of a blended family, because say I have children from my first marriage and then I have children with my current husband. I don't have any children, but let's pretend that. And if I give everything outright to my spouse when I die and my spouse survives me, he might give all of that property to like his kids from a first marriage and my children get disinherited somehow. So a lot of times people would prefer to put that in trust. So again, their spouse is taken care of during life, they get the income, probably principal if they need it, but then you can make sure that your children get some of that property that you had when you passed away. Another reason for trusts that also have to do with trusts for spouses is a lot of times it's used for tax planning, mainly trying to reduce the estate taxes when you pass away. So a really common trust that people did, well, some people do it now, but when estate tax exemptions were much lower, I'll talk about them later, but when they were much lower, there was a trust where you could make sure that you took advantage of your entire estate tax exemption by splitting up your property into a marital share and a family trust share. So when you pass away, an amount equal to the estate tax exemption, say it was $1 million, your entire $1 million would go to a trust for your family, which would include your spouse and your children and others if you want. And then the rest would go to your spouse, either outright or in trust. So it could take advantage of both of your estate tax exemptions and reduce the estate tax due, especially at your spouse's death. Asset protection is a little tricky with revocable trusts in particular. You can put in a lot of different asset protection pieces into trusts, and it's pretty flexible depending on how much you want to protect assets versus give your beneficiary flexibility. But when we're talking about protecting your surviving spouse's assets, say protecting against long-term care costs and nursing homes, if you put money in trust for your spouse from a revocable trust, that money is still reachable by creditors like for nursing home and long-term care costs. On the other hand, if you put it in a testamentary trust, so a trust that's created under your will, then that money, that trust for your spouse is protected. So sometimes people use a combination of the two to get the advantages of both. I already talked a little bit about this, but basically wills versus revocable trusts. Wills are not effective until you die. They don't do anything while you're alive. They just say what happens to your property when you pass away. Revocable trusts are effective as soon as you sign it or whenever you fund it, and you can have lifetime provisions while you're alive. They both dispose of your property the same way when you pass away, but a will, property that goes under a will has to go through probate, and property that's in a revocable trust avoids probate, at least to an extent. There's a couple pieces of paperwork to file with the court, but for the most part, it avoids the hassle of probate, which is one of the big reasons that people like to use revocable trusts. Some other advantages of revocable trusts, like I mentioned, asset management during life. One of the big reasons that we recommend revocable trusts for people is for planning and taking care of their property when they're incapacitated. So you can set up a revocable trust while you're alive and well and you're capable. You can be the trustee of that trust from the beginning. And then if you become incapable, you can designate a co-trustee or a successor trustee that will take care of your property while you're incapable. So you can still make sure that your needs are taken care of. You can specify that your spouse and your children can still have access to your funds. So it really provides a more seamless way of planning for incapacity and making sure that all of your bases are covered in case you become incapable. Another advantage that applies to people that have real estate in more than one state, so say you have a vacation home in Vermont, if you have that outside of your trust, so if it's probate property, you have to go through probate in Vermont as well as in Connecticut. Whereas if you put that in your revocable trust, it becomes non-probate property and you avoid having to also go to Vermont to dispose of that property. Some controversial plans, I guess you'll call them. Using a revocable trust reduces the opportunity for contests, because when you go through probate, when you have a will that has to go through probate, it requires notice to all of the interested parties. So that includes people that would normally inherit, like say a son you haven't talked to in 20 years gets notice if you go through the probate property, and then they have an opportunity to contest that will if they think for better, well, whether they have a good reason or not, they have an opportunity to go to probate and try to contest that. Whereas if you have a revocable trust and you don't have probate, that notice isn't required. So it makes it a lot simpler. You can also disinherit your spouse more easily through a revocable trust. You all laugh. The one situation I've seen a couple times is if you're in the process of divorce, but you're worried that maybe first you die suddenly while you're still legally married to your spouse. In Connecticut, there's something called a statutory share, which guarantees that the surviving spouse gets a third of a life estate in your probate property. But that's only for probate property. So if you retitle everything in a revocable trust that you've created and nothing goes through probate, there's no probate property for your surviving spouse to take a share of. So any of you who are married and thinking about that, come talk to me afterward. Someone went, ah, like that. It also, I think I mentioned a couple times, simplifies the estate settlement process, both because you don't have those kind of notice requirements, and also pretty much everything is already in that revocable trust. And someone who's the trustee who's going to take care of your property has probably already been managing this trust for you before you died. So it's much easier and much more seamless when you have a revocable trust. Some of the costs involved, I'll go through quickly because I'm sure I'm over. Drafting costs. Revocable trusts tend to be a little bit more expensive than wills to draft, but most people have to weigh the benefits, and depending on what they want their estate plan to do, a lot of times they decide that the upfront cost, which isn't a lot more than a will, is worth it for the benefits that they're getting from a revocable trust. The probate court will also have to supervise testamentary trusts. So trusts that you're created under your will are under probate court supervision until that trust ends. You can waive periodic accountings to an extent. So every year or every 3 years, a lot of trusts have to be accounted for. You can waive that to an extent in your will, but you can't waive a final accounting. So there's fees for the probate court to oversee the final accounting for that, and hearings and filing fees and things like that. Probate court fees for estate settlement, though, are pretty much the same whether you have things under a will or a revocable trust, in Connecticut at least. In Connecticut, the probate court fee is based on your estate for estate tax purposes, which includes probate and non-probate property. So includes your whole estate, not just the probate property. So it doesn't matter if you have everything in your revocable trust or if everything's passing under the will, the probate court fee is going to be the same. Another thing that's pretty neutral between the two is taxes. Estate taxes, like I mentioned, include both probate and non-probate property. So putting property in a revocable trust is still taxed to you for income tax purposes while you're alive, and it's also subject to estate tax when you die. So tax savings isn't really a thing you can get from a revocable living trust. You can do some tax planning with irrevocable trusts, but that's outside the scope of this. And then I mentioned asset protection with the difference between testamentary trusts, trusts under the will, and trusts created for a spouse under a revocable trust. Trusts that you're trying to trusts that you're trying to build asset protection into for people other than your spouse, you can build similar provisions for tax planning and estate protection or asset protection into trusts under wills or trusts in irrevocable trusts. So you can do the same thing under either. Okay, quickly on dealing with incapacity. Some people think that joint accounts are the way to go, and they come in and say, well, what if I just, let's say my spouse just passed away, I don't want to deal with probate, and I have 3 children, but one of them lives nearby. I'll just title my bank account to be joint with my son who lives here in Danbury. That can work depending on the situation, but the problem is that maybe your main estate plan, your will or your trust, says that everything's supposed to be split equally 3 ways among your 3 children. Some people say that, well, my son will just split it up between my 3 children. You recall that joint accounts pass automatically at your death to that joint owner. So when you die, that account immediately becomes the property of your son. And some people, it does happen, some people just will do that and say this was for convenience purposes, I'm going to split it between my siblings, and it works out. But there's no legal requirement for that son to split up that bank account between his 2 siblings. So you can run into some unintended consequences when you pass away. Also keep in mind that while you're alive, your son can have access to that joint account, and his creditors can also get to that joint account. So you're kind of opening yourself up to a lot more risks than you would with some of these other tools. So a power of attorney is one of the main basic simple documents that we use for management of financial, for bank accounts and other financial institutions. There are 2 types. There's a durable power of attorney and a springing power of attorney. The durable power of attorney basically takes effect as soon as you sign it. So if you're going to make, say, your spouse and that son who lives nearby as your agent under your power of attorney, as soon as you sign that, your spouse and your son have access to your bank accounts and other finances. A springing power of attorney only takes effect when you become incapable. So you can sign the springing power of attorney, and you still have control over your accounts. And then if you become incapable, then your spouse and your son, or whoever you name, can take over. One of the reasons we don't like doing springing powers of attorney is that it can be really difficult to use. So somebody has to go to a doctor and get a certificate that says you're incapable. There's just a lot more hassle, and especially with banks, a lot of the big banks don't do well with normal powers of attorney or durable powers of attorney. So a lot of people, or some people come in and say, well, I don't know if I want to give my son power of attorney now. I don't really want to sign a durable power of attorney, but why don't we do a springing power of attorney? And my son, if I become incapable, then my son can take care of everything. We try to remind people that a power of attorney is a really powerful document. And you really need to trust completely whoever you're giving whoever you're giving power to under your power of attorney. So we try to ask them why, if you don't trust him to take care of your property now, what makes you think it will be different when you're incapable and you also can't take care of your property? So it's something to think about. You really need to make sure you're picking the right people under these documents. As far as healthcare goes, living wills you're probably familiar with. The traditional, most typical one says that if you're terminally ill or permanently unconscious, you don't want machines to keep you alive. So you don't want a breathing tube and you don't want feeding tubes. We've also done living wills that say do absolutely everything you can to keep me alive no matter what. So it's pretty flexible depending on what your wishes are for end of life. Part of that document in Connecticut is also designating a healthcare representative to carry out your wishes. So you can name different people or the same people for end of life and sort of everyday healthcare decisions. So there's that big end of life decision that everybody thinks of when they think of living wills. But there's also sort of the daily decisions, like, or just say you had surgery for something minor, you're fine overall, but you're unconscious still, and somebody needs to know if they can give you aspirin or something. There's those kind of decisions that you would need a sort of everyday healthcare representative for. Allison is usually the one that goes over this, but DNRs and living wills are not the same thing. Sometimes people come in and ask us to write them a DNR, and we can't do that. That's a medical order that doctors write. The difference is that living wills are more about sort of usually your end of life decisions and whether you want to be maintained if you're terminally ill or permanently unconscious, what you want to have happen. A DNR comes into play, like say if you have a heart attack, do you want the paramedics to give you CPR? So it's a totally different, it covers different situations. And again, a living will is a legal document that we can draft for you. A DNR is a medical order that a doctor has to draft for you. And Allison's going to talk a lot more about conservatorships later, but I thought I'd give a very brief overview. A conservator of the estate manages your finances, basically similar to the kinds of things that powers of attorney do. And conservator of the person takes care of healthcare decisions. It can be the same person, it can be different people. There are two different types of conservatorships. One's voluntary and one's involuntary. They both have to go through the probate court. I should define a conservatorship in general, sorry. A conservatorship is when you have to go to the probate court and someone is asking the probate court to appoint someone to take care of your finances or your healthcare matters or both. A voluntary conservatorship is when you are still capable, but say your just bills are hard to pay or you just are really overwhelmed and you want the court to select someone to take care of your affairs. The court doesn't have to deem you incapable. You still have to pay probate court fees and go to hearings, and the probate court will supervise that. But if you are still capable and at some point you want to revoke that voluntary conservatorship, you can. An involuntary conservatorship, a court determines that you're incapable, and then you're incapable. And the conservatorship itself is pretty similar. It's just the matter of a voluntary conservatorship. You can choose your conservator, and you're a little bit more in control. I don't know how much you want me to talk about estate and gift taxes, or if you want to take over. Okay. Okay. 5 minutes or 3 minutes or something. So there's a unified estate and gift tax. So basically, you could call it a transfer tax, basically. Gifts that you give during your life and at death all have the same exemption, basically. So as I mentioned earlier about estate tax exemptions, maybe 10 or 15 years ago, they were much lower, so maybe $600,000 per person. This year, you probably sort of followed, or you probably all followed the Tax Cuts and Jobs Act that just came into play. The federal estate tax, gift and estate tax exemption this year is $11.2 million per person. So you can transfer that much during life and at death under the current legislation without incurring taxes. That makes it something like $22.5 million for a married couple total that they can transfer. So I actually read something today on one of our listservs that came through. Someone was asking how many people are actually affected by estate taxes now, the federal estate tax. And the person who answered, who's very good at taxes, said that out of every 1,000 estates, two estates will have to file estate taxes, and one will owe estate taxes. So it's 1 in 1,000 is subject to the federal estate tax under the current exemptions. In Connecticut right now, so this year in Connecticut, the exemption is $2.6 million per person. So a lot of people still aren't affected by that. Next year it goes up to $3.6 million per person. And then it's set to match the federal eventually, so that $11.2 million. The federal exemption, and presumably the Connecticut exemption that's following it, is set to what they call sunset in 2026. So it's supposed to come back down to the current exemption which is somewhere around $5.5 million per person that'll be adjusted for inflation. So Rich is going to talk a lot more about why you need to update your estate plan when these kinds of things happen, but part of this, the point of this is that estate taxes are not really a big concern for most people at this point. So you should definitely still do your estate planning, your wills, and your trusts for all of the other reasons that I talked about. But estate taxes, at least until the next legislature or who knows what's going to happen to them, for right now, most people don't really have to worry about estate taxes or gift taxes. Similar to that, my last point was the annual gift tax exclusion. So a lot of people give, say this year it's $15,000, and they give their grandchild, each grandchild $15,000 every year so that they don't have to worry about gift taxes. That's the max that you can give each person each year without even having to worry about it counting against your exemption. A lot of people used to do that because it helps get money out of your estate. So basically, you could get $15,000 a year out per grandchild or whoever you wanted to give it to, and you didn't have to worry about that money being taxed. Now, a lot of people say, well, I gave $15,000 and not a penny more. But with the exemptions that high, most people don't have to worry about meeting the exemption. So you don't really have to feel as restricted by that annual gift tax exclusion like you did before. Thank you all for listening to all of that. I'm done. If you have any questions, let me know. Rich is about to talk about why you really need to revisit all of these estate plans based on various changes in your life. So thank you.